So the next public hearing we have is on a trigger ordinance. And Mike, I might be calling you in on this some more. I have that agenda. You guys all have that agenda in front of you. It's called to order. We're gonna say at 9:31. Do I hear an approval of this agenda? Matt, one. No. First it. Sherry, second. All in favor? Aye. All right, the summary of this request is, and I believe this was on advice of Mike Homier, that we should have a trigger ordinance or a PA233 compliant large SES solar ordinance so that developers would come to us first at the township. If we don't have this, all developers will just go straight to the MPSC. So that is where we're at with this. And Mike, do you have anything you'd like to say about this?
Well, what I will say is this: it's not that they will, it's that they may, right? And one is required versus one that is optional. For example, if you have a compatible renewable energy ordinance, then they have to seek local approval first. And that's the reason for it. I don't necessarily disagree with Emily about workable ordinances. My problem with it is who's it workable for? You may have a workable ordinance for DTE or somebody else for that matter. What about the next one? What if it's not workable for them? And that's really the problem, because at any time during that process, workable or not, anybody, including DTE, could say, yeah, this doesn't work for us anymore, so we'll go to the MPSC. And that's kind of the problem I have with workable ordinances. I applaud DTE for trying to work with the township, and I'll leave the policy decisions to you. That's not my role. My role here is to render sort of legal advice to the township, not the policy issues. I'll leave that to the planning commission and to the township board. But the reason why the amendment is necessary is to force those unwilling developers to seek local approval first and not just rely on the graciousness of the next developer to try and do so. That's my biggest concern. Now, the courts are going to determine whether or not, within the scope of PA233, you have retained your zoning jurisdiction outside of those areas covered by section 226, subparagraph 8, dealing with setbacks and lighting and noise. I think you have. Other people think you haven't. MPSC is interpreted as one way that our clients are not happy with, and that's why we filed the appeal. So we'll have to wait and see.
Any questions from you guys on the board?
No questions.
Yeah, because you guys remember this, we got this in December.
Yeah, really.
And it has the requirements.
I think it's another level of protection for the township. That's how I'm looking at it, so I don't think I have any problems at all with it.
At one point, back in the last 2.5 years, it was somewhere, I don't remember where, but if we had a CREO and say Unadilla didn't, then that CREO, our CREO meant nothing. Is that true?
Mike?
I think my recollection is that may be how the MPSC has worded that in their order. I'd have to go back and take a look. But.
So there was something to do with money. If we had a CREO and nobody else did, we were out the money that we could get from.
So the PSC has redefined, in my opinion, what is meant by effective local unit, right? And the reason why that makes a difference is because of the community host agreement. So they changed that, at least in their order, to say an effective local unit is a local unit of government that exercises zoning jurisdiction, which then creates a whole host of different issues. Like, for instance, if it's in a township where it's county zoning, who gets that host agreement and the money that comes along with it. Those are all questions that eventually will be answered by the courts or otherwise. So, with regard to cross-jurisdictional projects, I think there's still some ambiguity under the order on how it's going to work and what the MPSC can or cannot do, and whether that's binding on anybody in that administrative process, because that's what it is. So even like, I'll give you an example, even in the MPSC's order, they admit that they don't have the authority to adjudicate whether or not you do or don't have a CREO. So I don't know where that ends up. Maybe circuit court, I don't know. I don't know yet what the Court of Appeals can do with it either, so.
That does fall into us though, because at the Burma Farms, Unadilla does have a section in Unadilla that's connected to Burma Farms. And they've already made their plans. They're set with it. So if we have a CREO and they don't,
I don't think this is technically a CREO, that's what we have. I think this is a workable ordinance, it gets us to the minimum state requirements.
oh, I thought we were talking about CREO.
We are, that's what our trigger ordinance though, it's not a full-blown CREO. If you remember, Mark sent us Deerfield Township's proposal, which was a more complete, it was a complete CREO, where this is just basically more what, I think it was Conway, it's like.
Then I misunderstood, I thought they were.
I want to make sure that we're clear. If the township adopts this provision, then it's our position it becomes a compatible renewable energy ordinance.
Okay, it just didn't seem as complete,
So it is a CREO.
Well, that's because you already have the other portion.
portion of it, okay.
We're just talking about this specific
Because I know it was
add-on.
accessibles.
This aligns your setbacks and noise and fencing and lighting with the requirements under section 226, paragraph 8.
Okay.
So what would happen in a case like that with Burma Farms, and we're both have property that meet each other? Part is in Unadilla and part is in Iosco.
So right now, we're only talking about the jurisdiction on the zoning for Iosco Township. When you say they have their plan set, I'm not sure who they is.
Unadilla Township has already agreed to it, to solar.
Related to this project?
It connects.
I maybe just speak to it? Yeah,
Sure.
so DT does have an easement interest in a portion of the Burma Farms property that goes into Unadilla Township. We spent time with them in the last year working on a workable ordinance. They adopted it with no one showing up at their public hearing. There are no developers prospecting in Unadilla Township because it's so far from transmission that they're not feeling any pressure, so they just adopted a workable ordinance, and they haven't had any other inquiries from developers. It's just us, and we're committed to working with them, just as we've said we're committed to working with you. But there is just a small nugget of the project that extends into Unadilla.
So you'd only get to the issue with respect to the cross-jurisdictional boundaries of a single project if there was an application filed with the MPSC where township either didn't approve or denied this project under your zoning ordinance as it exists, as the application exists on the conditional rezoning.
Anything else from you? Now we're gonna do a call to the public on this. 3 minutes. Anyone? I have this, anyone? No one wants to, okay. I'm gonna close the call to the public.